of the company Public Sector HR Consultants. And Ronnie was not available for the webinar today, so I was asked to fill in for her. Let me just say that I am mostly retired these days as a municipal consultant. I still have a few leftover clients from yesteryear. But Ronnie and I have worked together for, going back over 25 years in developing personnel policies, compliance policies for employment purposes, and the like. So actually this transitional duty program is something that Ronnie and I started working on. Gosh, my memory would have to take me back to around the turn of the century, around the year 2000. I assume that most of the participants in this webinar are familiar with the concept of transitional duty, but let's just take a quick look at it in the slide number 2. Now, I have found over the years that it is best to have questions as they occur rather than waiting until we get to slide 21 for the questions to come in. Now, it's my understanding that if someone has a question, they should type it into the chat. Is that correct?
So we can have them type it into the chat, but as well as you can say, does anyone have any questions? Someone can raise their hand and I can unmute them as well.
Very good.
Perfect.
Okay, well, let's get right into the meat and potatoes of this, as they say, and let's look at the slide number 2 of 21, which says, what is transitional duty? And as you can read there, that it should be part of an absence management program that the municipality or the public authority has. And by absence management program, this is comprehensive right down from, shall we start with simple things like tardiness, all the way through to being out of work for an extended period of time, perhaps even qualifying for such things as the Family and Medical Leave Act, or maybe even getting into civil service rules and regulations on how to terminate an employee who's been out for more than 1 year. So if you don't have an absence management program, this would be a component that would normally be part of one. It is a temporary work assignment. It is by concept designed to transition the employee back to work as soon as it's medically reasonable. Now that's its core essence, that it is there to take an employee from having a disability where they can't do the work to where they can do all their full duties. Now you might notice here that we don't use the word light duty. There's a reason for that. This is transitional duty. Now usually transitional duty is light duty, but when we think of light duty, we're usually thinking about a labor intensive position. So normally I need to be able to lift 50 pounds, I need to be able to be on my feet for 8 hours a day and the like. So if I have an injury to my body, I very well would not be able to do all those things. Maybe I could still lift 5 pounds. Maybe I could be on my feet for 3 hours with a little bit of rest and then again for 3 hours, or maybe I can't even work for a full day. And that's where the concept of light duty comes in. But when we're dealing with administrative and clerical workers, it's not really a matter of light duty, but they still may not have all the responsibilities that they would have going back to their full job. So let's take a look at the next slide then from there. Actually, that's help me here. I'm getting used to this. You're now just looking at what is transitional duty. I did not have that slide up. So take a moment to look at that. Now we'll go to slide 3. Why should you have transitional duty and return to work procedures? Well, if you don't have these procedures written down now, when the opportunity comes to you, you would be making that decision on the spot. And you may find yourself getting into some complications dealing with civil service rules and regulations, with disability rules and regulations under the Americans with Disabilities Act and the like. So it's good to have a program in place so that when the situation occurs, you already know what your policies and procedures are going to be. Now, what are the costs of not having transitional duty? Well, right up front, we can think about it in the sense that if I don't have transitional duty program and somebody has an illness or injury that keeps them from working, whether it be on the job or off the job, then I'm going to be very likely paying that person and maintaining their medical insurance and not getting any productivity. So I don't have the opportunity of getting the value of that employee. I may have to go hire another temporary employee to do all of these tasks. And so now I have double the cost in order to get that particular job done. Now also, as it says, the transitional duty aspect, the person very likely may be out of work longer. We'll get into that discussion a little bit later. One of the examples that we have here is this motor equipment operator. He's at $15 an hour, back injury, loss of 1 day work. He reported the injury as soon as it occurred, and the forms are all filled out completely. So this is what you call a fairly ideal situation. The employee knows about the transitional duty program. The supervisor already has something in their mind for what to do on the transitional duty. He's returned to work the very next day, and he's accommodated with these restrictions that the doctor said were necessary for him to be able to perform duties, even though not the full duties. Now, want to go back on this, that the supervisor has designated transitional duty assignments. As we had back here, this is a motor equipment operator. A rather common duty for a motor equipment operator in a highway department would be maybe to go out and do certain inventories in the machine shop, or maybe even go out and do what's called sign inventories. There's usually a task or two that this highway superintendent has that has not been taken care of because there are just other priorities of more importance. So the supervisor, or in this case, the highway superintendent, has in their mind, well, if I have somebody who needs to have this transitional duty for 1, 2, 3 days, or maybe a week or two, these are the 4 or 5 jobs that I had them to do. Now, this employee, Joe, of course, can still lift and push and pull. So there might be simple things like painting a door, building a new tool bin in the machine shop. Again, these are various duties and responsibilities that just haven't been taken care of because everybody else was busy doing other things. And this just is another slide to give a list of what this employee might be able to do: driving, doing an inventory, operating certain types of machinery, and of course, flagging traffic if there's that type of work. So you can see here that under a workers' compensation claim, that's why we're very interested here with PERMA, there is no indemnity cost. The medical is what it is, but there's no other indirect cost of that being to have a substitute come in and fill in for this work that needs to be done. Now, the next example, where there is no transitional duty, you have another situation, a motor equipment operator making the same amount of money, back injury. He doesn't return to work, and he actually called in sick, as would be the case under perhaps his collective bargaining agreement or under an employment handbook. And all he says is that I'm out, I hurt my back, and we really don't even know what happened. We don't even know that this is a workers' compensation claim yet. What's worse in this particular one is that the incident is assumed to have happened in the past, so no form has been filled out, and now he's coming in saying he has an injury. Of course, when we see these things, we often become somewhat suspect that maybe the injury did not happen on the job, it happened off the job. And I believe everyone could read the rest of this as far as the paperwork and the late notification, getting it into PERMA so that they can manage the claim. no medical documentation to support the injury, delayed treatment. Eventually, the employee wants to get back to work. There's some concerns over whether or not he has the full capacity to do all the duties and responsibilities. And as again, the scenario spirals out that the supervisor feels that the employee is intentionally missing work. This next slide just continues to show how it cascades down into a problem, right down to the supervisor doesn't even want the employee back. And you can see here where the expenses start to mount. The indemnity is there because of lost time at work, and also the medical cost spirals because the employee is not getting back to work. And then all this indirect cost of having other people do his job over time. You're paying out leave accruals to this person where they probably could have been back to work. And also you're continuing to maintain their health insurance, though you're not getting any productivity. So let's pause there for a minute. Were there any questions that come up just in looking at those scenarios?
No questions yet.
Okay, well, let's move on to what are the benefits of transitional duty, even though we've kind of touched on this as we went through the problems of it. So obviously there's decrease in workers' compensation costs. There's decrease in these indirect costs of having other employees do the work. Again, because you have this laid out very carefully, we'll go into this in more detail later. You're in compliance with the Americans with Disability Act, the ADA. You're getting productivity from the employee opposed to no productivity. It may not be full productivity, but at least you're getting something. And then you have this accelerated reintegration of the employee into full performance. There have been ample studies out there for literally decades that shows that an employee who is out of the workplace due to an illness or injury, whether it be an on-the-job illness or injury or an off-the-job. Now again, on-the-job worker compensation, off-the-job, we're usually talking about New York State disability insurance. But if an employee is off the job, out of the workplace, no longer in their standard routines, that the time from the injury to when they're able to return to work without any restrictions is longer. And in many cases, studies show that it could be 2 to 3 times longer than otherwise necessary. One can use their imagination on why that is, but most of the studies point to is that as the employee gets out of the habit of reporting to work, they tend to linger, they don't tone up the body. So let's say that's labor intensive. They may be going to therapy, but it's going to be minimal. They're not coming back in and gradually retoning the body to get their strength back. Similarly, if it's an administrative position or a clerical position, they're just getting into somewhat of a rut of not reporting to work when they actually could. As far as the employee benefiting, as you know, workers' compensation is not full pay. They may be, as an employee, using some of their leave credits to coordinate with their worker compensation benefit to be in full pay, but they are drawing down their leave credits, and that may eventually exhaust itself. You are not required to maintain their medical insurance beyond the period under the Family Medical and Leave Act, and some towns and authorities may be so small that you're not even required to be under the Family Medical Leave Act, which is roughly 3 months. So if an employee is going to be out for a longer period of time, they are maintaining their full pay, they're in insurance benefits for their medical, None of that is compromised. Same thing is there's no break in the New York State retirement accruals. There's no break in their accrual of paid leaves. Many employment manuals or labor contracts, let's take sick leave for an example. I work a month, I get a day. I work a month, I get a day. If I don't work during that month or a substantial part of that month, I don't get that day. Some employment policies and collective bargaining agreements would also say that you need to work a certain number of days in a month in order to maintain your vacation accruals. So here again, there's no interruption in the paid leave accruals. We've already talked about this other aspect about just improved morale, self-esteem, and faster recovery. Now, how to go about implementing a transitional duty program. There's going to be a second handout where we actually have a sample of a program. But let's start through this whole aspect of what does it take to have any good policy or procedure. You need to have a commitment from top management. Now, for a municipality, that's going to be the town supervisor and the town board, including other elected officials such as the highway superintendent. For a village, it would be the same from the mayor and the trustees. If it's from an authority, it's going to be the board of directors and whoever the executive director is. There needs to be a developed policy. Some situations you need to negotiate the policy with unions. When we look at the sample a little bit later, I will point out where the unions have input and where they do not have input. You publish the policy in the employee handbook and you train your supervisors, you communicate it to the employees. Now, as far as developed job descriptions, because this is the public sector, each of these positions is going to have a job description as per your local civil service agency. In that job description is going to have a list of things that that job might do. That doesn't necessarily mean that's the ones that they do. They may only do a fraction of them or may do all of them. And then, of course, there's always that bottom line that says, and other related duties. But it still is a good practice to write down the, not necessarily job description, because you have that through civil service, but write down the duties and responsibilities for that position so that you would know where an employee may be restricted and where there might be an opportunity for some transitional duty. Again, I'm reluctantly avoiding using the word light duty. So we'll pose a few questions for you. Should transitional duty be provided for both work and non-work related injuries? As a consultant to my clients, I say yes. We want that employee back to work for various reasons, because even on an off-the-job illness or injury, there are some indirect costs. Now, you're not paying for the medical, you're not paying necessarily for lost time other than the paid leave accruals that they'd be drawing down. But let's say that they have some leave accruals and you need to have that work done, you're going to go out and hire a temporary employee. So now you have additional cost. So I would say, yes, you should apply your transitional program, whether it's off the job or on the job. Now, what if more than one employee is injured and there is only one transitional duty assignment? When we get to the example a little bit later, we'll talk about this some more. But quite often, this is a problem. If you have a highway department with 10 employees and 2 of them are out on a disability, it may be difficult for the highway superintendent or the DPW commissioner to come up with enough work for those 2 employees. So sometimes this is a problem. I would say that you should be open to having as many employees on transitional duty as possible and come up with scenarios for doing that. You'll see a little bit later in our example that all of the transitional duty does not need to be in the department in which the employee is normally assigned. Now, in some cases, that may get involved with some negotiations with the labor union, and we'll talk about that later also. What do I do if the employee doesn't want to return to work? You're going to see in the example that first thing we do is we notify PERMA. The situation here is that if work is available inside the broad scope of the employee's civil service job description, even if it is not full duty, the employee doesn't have the opportunity of not returning to work. They would be compromising their benefits, and also they could be subjected to some discipline under civil service rules and regulations for refusing to do work. Again, if you have a program that's well understood from the beginning, we don't get in a situation where we have to be so critical about this. How long does the employer have to hold a job? Well, in most cases, again, we're talking about an employee who's in the competitive or non-competitive class under civil service. And whether it's an off-the-job or an on-the-job injury under civil service rules and regulations, these are numbers 71, 72, and 73, the employer has to hold that job open for roughly 1 year. Now, a little nuance here that we could talk about more. If it's an on-the-job injury, on-the-job workers' compensation injury, it is 52 cumulative weeks. If it's an off-the-job injury or illness, it's 52 consecutive weeks. Now, that doesn't make a whole lot of sense. You'd think that one would be more generous the other way around. If I'm hurt on the job and I'm out for, let's say, 13 weeks, and I come back for 10, and I have another injury, it restarts the clock. That's not how it works. It's 52 cumulative weeks for an on-the-job injury. Now, the easy part comes for the off-the-job injury. If somebody's out for, let's say, 11 months and 3 weeks and comes back for 1 day, they restart their clock. So again, we'll talk about that more if there are questions a little bit later. I guess I just kind of answered this next question here. What if the employee has intermittent lost time from work for the same injury? Does Section 71 count continuous or cumulative? Again, to repeat, this is for an on-the-job injury, 71, and it is cumulative. The next is if our injured employee meets the eligibility requirements under the Family and Medical Leave Act, can we designate his workers' compensation leave as FMLA? They should run coterminous. So it's the person is out of work, you should flag it right at that particular time. Again, some of the municipalities and authorities are so small, they don't have the requisite number of employees. They're not required to have a Family and Medical Leave Act program. Many small towns that I've worked with over the years have adopted it. We call it the Family and Medical Leave Program instead of the Family and Medical Leave Act, and it replicates the act. These scenarios of this guy was never a good worker, can I just get rid of him? Because of Section 71, 72, and 73, where civil service guarantees their employment in their job for this 1 year, the answer is no. Can you compel an employee to retire? Again, the answer is no. That doesn't mean that you can't have a conversation with them. Let's say that they're over the age of 55 and they have at least 10 years of service and they may not be coming back to full duty for a while. You can have a conversation with them of would you consider a retirement? And there are also opportunities for you to offer some retirement incentives that might inspire the person to retire, but let's be careful about this word compel. What happens if an employer is not consistent with return to work procedures? Well, it's the same thing there as it is with any employment policy or procedure. Consistency is incredibly important in order to avoid claims of discrimination. Let me just add in here, discrimination in the workplace is not unto itself a bad thing. You can discriminate in such ways as I'm going to assign the most talented employee to do that job. I'm going to promote the employee who has exhibited the best potential. See, that's good discrimination. We're all aware of where the bad discrimination comes in, and these are the protected characteristics that you know of race, religion, creed, etc. So anytime that you start allowing a program for someone but not for someone else, if that person is in a protected characteristic, they come in and say, you did it for them, you didn't do it for me, it's because I am fill in the blank. Guess that gets us through those, right? I'll try to be a little bit less clumsy with this. There we go. So let's take a pause right there on the slideshow presentation into this sample and ask again if there's any questions.
No questions so far on my end.
Okay. Now, are you seeing the transitional duty screen?
Yes.
Okay.
Looks good.
This document, and by the way, anybody who would like to have a copy of this, I assume that there's a way they can get in touch with me so I can send this to you, or, well, actually, you have it. That's right. Everyone has this. They can download it. If you want it in a Word format, I can get it to you. But this is taken out of several collective bargaining agreements that I've worked on over the years, as well as some employment policies. So let's take this through in its entirety. As you see, it's laid out here with a purpose statement. It talks about the eligibility, the assignment, wages, duration, and that refusal. So here, it clearly states that the purpose of the transitional duty program is to allow an employee who is temporarily, partially disabled for them to return to work in an assignment that meets both the needs here at the town and the medical limitations of the employee. If they're unable to perform the full duties or responsibilities of the regular position, the department head, now again, fill in the blank there, you may want this all the way up at the mayor or the town supervisor or executive director level, or just at the department head, may, on a case-by-case basis, these words are there on case-by-case because we're making it clear that this is not open to everyone. Quick footnote, we just talked about how if it's not open to everyone, you risk discrimination. We're going to try to fill in the blanks so that we can avoid this, but let's start off by saying it's not guaranteed, it's case-by-case. So the department head may, on a case-by-case basis, require such employee to return to work in a transitional duty assignment, avoiding use of the word light duty. The exercise of this transitional duty program shall not establish any precedent or commitment to provide transitional duty assignments to any other employee at any time in the future. Now that's more, let's call it legalese speak, goes in with case by case to make it clear that the policy of this program is that it's not a guarantee. It's available if we can make it available, if the capacity to make it available is there. If there's no work for this employee to do, then there's no transitional duty. So eligibility. The employee must be classified as partially disabled at 50% or less, and the employee must have a prognosis of full recovery within 6 months. Those numbers, 50% and 6 months, are arbitrary. They could say 30%, they could say 60%, it could say 4 months, it could say 7 months. The reason the numbers are there is to set up a distance between this program and reasonable accommodation aspects of the Americans with Disabilities Act. So we're saying that there are limits to this program. It has to be where it's a 50% or less disability, and that's of course determined by the medical provider. and we need to have a prognosis. I'm going to stress prognosis of full recovery in 6 months. The doctor might say, oh, okay, this person has going to have some laparoscopic surgery to their kneecap, and they're going to be out for 3 months. So obviously they're not more than 50% disabled, and the doc just said that should be back to work in 3 months. Well, after 2.5 months, there's still some swelling in the knee, some other tissue flaked off. They need to go back in, or there needs to be some additional therapy. And suddenly the doctor's saying he's going to be out another 4 months. Well, at that point, you go, now I'm up to my 7 months. I've gone over my 6-month threshold. Therefore, I need to take this person off of transitional duty. Now, that's a harsh reaction to just 1 more month out. You could discuss it, but again, you want to be consulting with your labor consultant or your human resources office or your attorney on whether or not you're starting to develop a reasonable accommodation that would go beyond transitional temporary status into full-time status. So for the purpose of this program, full recovery is defined as the ability to perform the full duties that they held when injured. Now, as far as the medical findings, they normally are the result of the examination of the employee's physician. My guess is that many of you have had a report come back from the employee's physician that just does not tell you what you need to know. Now, of course, you can work with PERMA, you can work with your human resources office. There are forms that can be filled out that it's called fitness for duty, where the doctor has to fill in how much this person can and can't do as far as sitting, standing, pushing, pulling, lifting, all those different things, use of hands, use of legs, all of it. That sometimes needs to be sent to the employee's physician with the requirement that that be filled out for the employee to be in compliance. But normally, again, if we have a good program in place, everyone knows that it's there in the beginning. When somebody has an illness or injury, that form is given to the employee to give their physician, and the employee's physician's examination suffices. If it doesn't, this policy has, if there's a dispute, it's submitted to the state insurance fund consulting physician. There's other options there, but here we're just saying that it goes to a consulting physician. And again, I talked about this form. It says the town will determine the documentation acceptable for establishing the eligibility and determine their physical limitations. So I expect there might be some more questions on that, but let's go through the rest of the program. Number 3 is the transitional duty assignment itself. It says here clearly, may not necessarily correspond with their regular job duties. The assignment may involve performing some duties of the regular position and some duties of another position, or a combination of tasks from several positions. The assignment may be at a different work location and or have a different schedule than the employee's regular position. There's a town in the Catskills some years ago, and even when labor-intensive positions had someone out on a disability, and there was no work with inside that particular employee's regular department, they would go over and work in the town hall. In some cases, they would help with doing some filing. In some cases, they would help with tax assessment. They would get involved in various types of duties that did not require a lot of advanced training. Basically, they would be shown what to do and they would do it. So here you had it where it was out of their normal job. It was in a different location, and it might even have a different work schedule. So I'm going to take this as an opportunity to talk about where I said sometimes the union might have to be involved. Now, in a labor contract, it quite often says that here is the starting time and the stopping time, and here is when the breaks are going to occur and when lunch is going to occur. And it might often say that if in the event there's an opportunity to work overtime, that employee has the right to work overtime. Now, you need to sit down with the labor union and say, well, okay, this person's going to have a slightly different work schedule. They may be starting at a different time. They may be stopping at a different time. Their breaks may be a little bit different. And if there's overtime in the department, of course, they're not eligible for it because they are in transitional duty. They're not able to do their full duties and responsibilities. So there's not a lot that needs to be negotiated with the labor union. Now, your labor union might say there is, but in reality, there aren't a lot of things that need to be negotiated here. But I've just mentioned a couple. The wages need to be the same. The duration of the assignment, this is to make it clear that it shall not exceed the 6 months that we had above. Again, that's an arbitrary number, or the date of full recovery, whichever comes first. The town may require medical examination ordered by the town as a condition of allowing employee to return to full duties. I know here it says the town may. I would insist that you always do that. As far as the refusal of assignment, we talked about that a little bit earlier, that if they refuse the transitional duty assignment, or they refuse to submit the medical examination that you ordered, refer it to your comp carrier or New York State disability insurance carrier for benefit determination. Again, I'm leaving out of this particular policy anything that says disciplinary action for insubordination, but that is certainly an option that one would have under civil service rules and regulations and or a collective bargaining agreement. So that gets us to the bottom of this policy, and we've gone through the slide presentation. So I hope that there are some questions that we could share with each other.
We did have someone raise their hand. Tim, are you able to hear us? I think Tim called in on audio because it says he doesn't have any audio. So Tim, if you can hear me, do you want to type in that question in the chat feature? Anyone else have any questions? Okay, we just got Tim's question. Don't we need a benchmark in the job descriptions with regard to working requirements?
I'm not quite sure what you mean as a benchmark. Again, your job descriptions, you may have some internal job descriptions, and I don't mean to go off on a tangent here, but technically speaking, only job description that exists is that is developed by your Civil Service Commission. Now, I know that there are consultants out there. Ronnie does this, Ronnie Travers. There are HR departments that have what's called their internal job descriptions. Those under civil service rules and regulations really don't exist. Now, they may help you out because they give you more detail, but the only job description that is legitimately there is the one developed by civil service. Now, I earlier said that it is good to list down the duties and responsibilities, almost a to-do list for your various employees, just as a good checklist. Again, when you look at a civil service job description, it's going to have all the possible things that employee might do. Not necessarily does your employee do all of them, or even most of them, but certainly some of them, or else they're in the wrong job classification. They have the wrong job title. So when you say a benchmark, if we mean a performance standard, Tim, help me out there, because a performance standard is a little bit different. Now, performance standard would say, how fast do I have to type? What type of software programs do I know how to operate? What type of machinery do I need to operate? What type of code and rules and regulations do I need to be familiar with? Those are all performance standards. And there I would say, yes, you should have those benchmarks. Most of you won't, but you should.
Tim also said Westchester County job descriptions do not indicate specific weights. Westchester County administers civil service for local towns and villages. If the transitional program requires 50% or 40%, what is the initial number you are taking a percentage of?
It's the disability, and again, that is determined by the treating physician. So the physician is going to say, and again, your consultant at PERMA will help you on this, that you're going to get a report back from the treating physician going to say what's the magnitude of the disability. And I want to go back and I want to stress that 50% and 6 months, it's arbitrary. It shouldn't be wide open so that it's like maybe 100% and unlimited, because there you have reasonable accommodation under the Americans with Disabilities Act. What you're saying is you can be fully disabled and there's no end date, and I'm going to make certain that you have, quote, light duty. That's in essence what you've done. You're going to say, I'm going to allow you to work here under these conditions. So that's why we put these numbers in there, whether it be 50%, 40%, or otherwise, in 6 months or otherwise. Does that answer your question, Tim?
Somewhat, he said, and he said, different question. Do you have examples of transitional duty for firefighters?
I do not have them at my fingertips. I've worked with the city of Elmira and some other municipalities over the years in coming up with programs for, now here we get into the thing called light duty. And I'm going to try not to go off on a tangent. Police officers and firefighters have a section of civil service law, and it is called light duty. This is for when someone is hurt in the line of duty. And if there are opportunities for them to come in and do less than their normal functions, firefighter would not go out on fire calls, for example, or a police officer might be taken off the beat and not have to carry a weapon. You can assign them under civil service law to do light duty for a certain period of time. And again, I mentioned with Elmira and some other cities, Schenectady, over the years, there's a fairly long list. We've come up with light duty assignments for them to do. I would suggest that, if you have more detail there, to ask around for other municipalities that might have light duty assignments for their police officers and the firefighters.
Perfect. So we do have another question from Donna. Question on section 7.1 with an on-the-job work injury. 1 year lost time. Can separate accidents be combined to achieve 1 year, or is it 1 year's lost time per injury? Thanks.
Okay, so Donna, if I have this right, you're talking about we have an on-the-job injury, and let's say it's for 10 weeks. The employee returns to work, goes back out on, I'm going to say it doesn't matter if it's the same or a different injury. Under Section 71 of Civil Service Law, it just says 52 cumulative weeks. Now, in my 30 plus years of working with municipalities, I've never worked with a municipality that carefully kept track over 1, 2, 3 years and said, aha, I've got 52 weeks. Let's be rather candid here. Occasionally in the workplace, we have people that we sometimes call them frequent flyers. You can almost count that they're going to go out on 2 or 3 weeks, maybe even 2 or 3 months of disability leave, worker compensation every year. You just see a pattern develop. I know that PERMA has seen this. I've seen it. Probably you have all seen it at one time or another. So these frequent flyers, we go, well, okay, I understand civil service law. Once they get to 52 weeks cumulative, I'm going to drop the papers and we're going to get rid of this person. I've never seen anybody actually do that. Now, I do know situations where after 4 or 5 years, an employee's been out quite often. And at that particular point, we start the proceedings, and we start it almost from the next incident, saying, listen, you've been out 62 weeks in the past 5 years, and we find that to be excessive absenteeism. And then we start the process of saying that if you're not back to work at a certain time, we're going to terminate your employment under Section 71. But when you start getting to that situation, you better be working with your municipal attorney or your human resources office. It gets complicated.
Okay, next question we have. What if the transitional duty doesn't work out? For example, employee just doesn't do the different work properly. Can we force them back out on workers' comp?
It depends on how your policy is written. If you follow the sample that I put here, the answer would be yes. Just back on that last question, that only emphasizes the need to have a policy. Because if you don't have it written down and you brought the person in, you've given them a transitional duty, let's say they're breaking everything and losing everything, you go, whoa, that was a mistake, and you put them back out, they're going to question what your motive is. And you could also find yourself perhaps being discriminatory.
Wonderful, Michael. So I think that's all the questions we do have. Anyone else have last minute questions? If you do, you can send them through email to me, or I can give you Michael's email as well. We can definitely get you in contact with him. Michael, do you have any questions for me?
No, and please do. Again, even though I'm mostly retired these days, I'm always glad to help PERMA out or any municipality with questions like this. So just feel free to contact me with a question, no charge.
Perfect. We definitely appreciate it. The handouts are able to be downloaded and saved. We have a PDF form and a PowerPoint form of the presentation, as well as the last PDF that Michael provided. And if you do have any questions, you can email memberservices@perma.org, and I handle that email as well. Or my personal email is kfreer@perma.org. Thank you so much, Michael. I really appreciate you all coming, and I hope you have a great day.
Very good.